I am now a senior program officer working with the Muslim Women's Research and Action Forum. I graduated in 2008 at the Open University's BA program in Social Studies. This helped me to further my education, and I have also done my master's in development studies and public policy.
You get to learn at your own pace. That is the best thing. Further, there are multiple entry and exit points with certificate level programs to graduate level programs up to postgraduate level programs. The department itself is a learning experience. It is where you can learn freely.
My field is development sector, working in INGOs for last 20 years, and following these two courses at OUSL helped me a lot in terms of deepening my knowledge and improving my analytical skills.
LLB degree program conducted by the Open University of Sri Lanka is one of the best law degree programs in the country.
I've written 2 novels and 2 collections of short stories. The novel, Playing Pillow Politics at MGK in 2012 won Sri Lanka's prestigious literary prize, the Gratian Award, all because of the knowledge and the experience I gained at the Open University of Sri Lanka.
Anybody interested in this course will definitely benefit in life, in society, personally, and give your best social human beings working together in Sri Lanka.
It is a golden opportunity, I believe, to broaden your horizons. And I consider BA in Social Sciences as a launching pad for dynamic and enterprising youth, and also those career professionals who want to advance in their relevant fields.
The Open University offers a very unique way for a student to study. Because it is distance learning, it gives you an opportunity of studying while getting along with your other aspects of life. For myself, I first entered law college, and I would say that the experience which I had enriched my legal career.
Invest and empower yourselves at OUSL for a brighter future.
Okay, thank you very much. I hope that I'm audible. Can you hear me?
Yes, Sanat, we can.
Yes, we can hear. Okay, thank you very much. So, good afternoon, session chair, authors, and the participants. I'm Sanat Vijay Singh, team convener law and the co-host of this session. I welcome all to the session 2, parallel session 5 in the International Open University Research Sessions 2022. In this session, we have 7 legal research papers. Now, I kindly invite Senior Professor in Department of Legal Studies, Kamina Gunaratne, to chair the session. Over to you, madam.
Thank you, Sanat. So good afternoon to everyone, and welcome to the International Open University Research Sessions for 2022, and in particular to this session on law. So today we have 7 presentations on various topics which are very interesting and challenging. And I'm sure we are all looking forward to hearing them. All the presentations have been recorded and will finish in 10 minutes. After each presentation, there will be a question and answer session for 5 minutes. And I look forward to all of you all participating in this question and answer session. Can I request everyone to keep your questions short and to the point so that we can take as many questions as possible in this short time? I would also like to request the presenter to participate in this Q&A session. And please keep your video on during that time while you're taking your questions. So those are just a few preliminary remarks. And can I now request that the first presentation be uploaded?
The impact of COVID-19 in the court's proceedings in Sri Lanka. A critical analysis on the scope for adopting the modern methods used during the COVID-19 pandemic. Impact of COVID-19 in Sri Lankan legal system. COVID-19 has impacted negatively not only the medical system but also the legal system. Courts all over the world have had to react quickly to the pandemic challenges and the resulting social distancing regulations. A large component of the legal structure has shifted to an online approach during the last 2 years as a result of the digitalization of the legal system. Multiple new trends have too emerged. According to prescription ordinance, certain actions have to be filed within a specific time period. If such time limits are not adhered, that would result in the dismissal of such appeals, applications, as well as actions. In addition to that, it was found that there were a lot of litigants and witnesses who could not come to Sri Lanka from abroad due to the travel restrictions in such countries to give evidence in pending cases. Sometimes, even within Sri Lanka, persons could not come to court due to various travel restrictions. To remedy those challenges, the Parliament enacted Coronavirus Disease 2019 COVID-19 Temporary Provisions Act. It became law of the land when the Speaker certified it on 23rd 8 2021. It must be noted that the operation of the Act made retrospective and it operates for a period of 2 years starting from 1st of March 20. Key benefits of digitalization of the Sri Lankan legal system. Digitalization would enable filing written submissions, petitions, and other related documents to the courts in electronic form. Litigants can also monitor the status of their applications via online. Judgments and orders can be obtained easily, and a huge amount of time and cost can be reduced by the introduction of these novel technologies. Litigants can interact with the justice system in a novel and improved ways with the assist of online portals. For example, court staff can provide information and advice, a method for paying fines and fees, and a list of opening hours via a portal, while citizens can schedule hearing for minor offences. In this new pandemic age, it is indicated that online methods of conflict resolution, often known as online dispute resolutions (ODR), can encourage resolutions while promoting social distancing. Even during the crisis, the swift move from traditional judicial process to an online method has aided the public, lawyers, and experts in assessing the justice system in various jurisdictions. The various methods adopted by legal systems around the world to overcome the challenges of COVID-19. As a prompt response to COVID-19 pandemic, many courts have quickly developed video conferencing facilities as a solution for hearing process. In reality, some courts have struggled with this due to various factors, while others have navigated the process with fewer complications. As a result of introducing these methods, courts' virtual hearings are becoming more and more common by the day. Normally, virtual proceedings were being conducted in the pre-COVID-19 crisis era, generally in criminal cases, where the accused could not produce physically before the court due to security reasons. Some of the technologies and methods of digitalization used by countries around the world during the pandemic era are listed below. They are online dispute resolution (ODR), e-filing and electronic exchange of procedural documents, artificial intelligence, improved client services and other online legal services, and virtual courts. The impact of the use of technology on court and the judiciary. It is to be noted that digitalization has different aspects. Some of them are storage of data, exchange of data, improving the structure and integration of it, and speeding up the communication. These aspects would ensure the reduction of transaction costs and unreasonable delay in legal proceedings. However, the modifications that were adopted in the court system were not uniform. This is due to the fact that the certain jurisdictions operate modern courts, which could more effectively utilize current technologies, whilst in many other courts remain to repeat decades-old methods to litigation, or even centuries. Nevertheless, responses varied, with some sectors of the justice system seeing an increase in workload and others seeing a decrease in demand. Given the advantages of continuing to provide court services, the use of the internet and other online technologies in the judicial system has raised interestingly issues about the impact on the right to access justice, the right to be fair trial, and the administration of justice in general. It is examined that the policymakers have been concerned about the reform programs' impact on access to justice, but their efforts have been hampered by the lack of standards frameworks for evaluating the impact of these initiatives on access to justice. What is holding back the growth of digital justice in Sri Lanka? Despite Sri Lanka's decades of experiences dealt with many disasters, COVID-19 offers a unique issue, necessitating the establishment of initiative frameworks. It is no wonder that during the COVID-19 crisis, e-judiciary is being praised as a better mode of justice administration, with enhanced efforts being made to achieve its speedy universalization across the country. Even though there is a lot of momentum behind it in other jurisdictions, in Sri Lanka, digital justice still has a long way to go. It is observed that the rule of law is a drawback in some countries, including Sri Lanka. On the other hand, the lack of required facilities and infrastructure are also hindering the digitalization process. More importantly, it would be a challenge to train the judges and court staff to use of digital technologies. If the training is underfunded, that may also delay the adoption of digital technologies into the legal system. In addition, computer literacy of vast majority of Sri Lankan population is very low. The level of automation at record rooms is still in its early stages, with more than half of all questions requiring human intervention. The use of digital solutions like robots, bots, chatbots, more advanced virtual agents with artificial intelligence, and machines learning at the help desk are currently limited. Recommendations. Aside from the growing need for widespread use of technologies in the court services, jurisdictions can reduce unreasonable delays by encouraging the use of alternative dispute resolutions and online dispute resolutions instead of pursuing traditional methods through the courts. Therefore, it is recommended that Sri Lanka should also introduce alternative methods of dispute resolutions by using these modern technologies. It is also observed that one difficulty of digitalization is that courts often lack the budget to introduce those technological advancements. However, courts can improve their system by using open sources and widely used software. Thereby, courts could promote sustainability by providing external services, open sources, and clouds while addressing other legal and organizational barriers such as e-filing and e-services submission date. It is recommended that legislature should introduce advanced laws or make amendments to the existing procedural laws in respect of day-to-day court proceedings. One procedural law that could be introduced is remote testimony of a witness via video conference by way of a request of a party to a case. It has opened many opportunities to think it an innovative manner as to how to overcome the difficulties created by the pandemic itself. It is high time for the legal fraternity and stakeholders to get actively involved in this process to adopt the methods that we have used to counter the challenges we faced during the pandemic in order to digitalize the existing court system in Sri Lanka. And thank you.
Thank you very much for that very interesting and very timely presentation. Is the presenter online? Can you turn on your video, please?
Yes, he is here, madam.
Okay.
Yes.
Wait, I can't see him. Okay. So we have 5 minutes for question and answer. So does anybody have a question? Any questions, please? Okay. Let me ask a question. I was really interested in your presentation, and I think this is really important and timely. Oh, I'm sorry. Okay, Padmanesan, you go first.
No,
go
please,
ahead, Padmanesan.
You finish, I will ask. I will go for
Okay.
second, no problem.
I looked at your abstract, and you said that you were doing doctrinal research. Do you think your research will be enhanced if you do some interviews of lawyers and judges and court staff to find out directly from them what their problems are and what the obstacles are that you need to overcome?
Yes, that's with regard to the process, what are the civil procedure code and criminal procedure code, they have already established several procedures to be followed. But those procedures won't help the lawyers, judges, and even the court staff to adapt these new technologies to their day-to-day activities. So that purpose, it is timely required to amend these procedural codes and all the rules and regulations in order to introduce these novel technologies to our legal system. So that is one thing that they have suggested. That is one thing that they are willing to have.
Okay, right. Okay. Go ahead. Thank you. Go ahead, Padmanesan.
Yes, it's really interesting presentation. I have a very small observation that you have used adopting the modern methods. So what do you mean by modern methods? Did you define?
Actually, in my research paper, I have gone through all the newest technologies that we have used, that things that we have never used before this pandemic, but the things that we have used during this pandemic period, such as the Zoom and other platforms, and also you may go through this Supreme Court website and all, you may find these e-filings and all. These things are novel things to us. So we should, my opinion is, we should continue with these novel technologies and novel modern technologies, which we have not used before this pandemic. And we should take this as a grant, and we should follow the same procedures that we have used during this pandemic period in order to keep up the smooth functioning of the court system, and that would help us to reduce the cost and the time as well. So these are the modern technologies I have gone through. I have cited in my research paper.
Thank you, Chamika. I think it's better to use global communication technologies or technologies, because the modern methods includes various varieties of that methods. So you have to specify, then that's fine. Thank you.
Thank you so much. Thank you for such.
Ruantika, I can see your hand up.
Yes, yes, madam. Thank you for your interesting presentation. Actually, I have one suggestion to improve your research. I would like to suggest you to take some kind of comparative jurisdiction. For example, in India and some the Denmark, they have some advanced features to enhance the effectiveness of court system using ICT. So I would like to suggest you to take some examples from experiences from other countries, developed countries, to suggest a more practical solutions to the Sri Lankan court system. That's all. Thank you.
Thank you so much. Thank you.
Okay, thank you. Any other questions? Okay. Thank you very much for that very, very interesting presentation, and best of luck for your continuing research, and I hope you'll be able to expand it. Okay.
Thank you very much, madam.
So our next presentation is number 49 on the does the pulse of an unborn create 9 months of slavery? I think this author has said that she will get a little delayed. Sanat, shall we go into that, or shall we go into the next one?
Professor, I think we can go into the next one, and then we can come back to this Ayodhya's one. Yes.
Madam, I am online.
You're online. Okay. Then we'll have your one.
Okay. The topic of the presentation: Does the pulse of an unborn create 9 months of slavery? A legal perspective in the light of the Texas Heartbeat Act. Presented by Ayodhya Prabhashini Ratnayaka. As far as the fetal medicine is considered, it involves with the study of fetal behavior and developments of a fetus in the womb of a pregnant woman. The developed techniques of ultrasound technology have convinced the world that the human fetus is an entity possessed of different sensory perceptions, including pain. As per the findings of the British Medical Association, a human fetus feels pain after 24 weeks of gestation. These scientific evidence have been presented through the emerging technologies such as medical imaging, electrical, optical, fetal monitoring. This phenomenon has led to the recognition of fetal rights in different jurisdictions in the world. The research problem analyzes the effect of the recently enacted Fetal Heartbeat Act in 2021 in Texas. The problem scrutinizes the fact whether the recognition of the fetal heartbeat impedes the reproductive autonomy of women. The methodology of the study is qualitative in nature. The predominant approach adopted here is the doctrinal methodology, which analyzes the Texas Heartbeat Act and international legal instruments such as the Constitution of USA and the ICCPR, the International Covenant on Civil and Political Rights. In addition to this, the author has analyzed primary and secondary sources of law, and these sources of law have been analyzed through the techniques of content analysis. Fetal Heartbeat Act 2021 was enacted to impose certain restrictions on the termination of pregnancy once the fetal heartbeat is detected. In the opinion of the medical experts, the fetal heartbeat is started after 6 weeks of gestation, and if any physician supports in the termination of pregnancy without performing a test to detect the fetal heartbeat, is completely liable under the law. It is clear that the discussion part 2 gives a small idea about the fetal heartbeat, that it states that it is a key predictor of the fact that the unborn child will reach the live birth, and also as far as the Texas Heartbeat Act is concerned, it defines the fetal heartbeat as a cardiac activity which starts at a biologically identifiable moment when the fetal heart is formed in the gestational sac. Discussion part 3 is about the decision Roe versus Wade, which was considered as one of the landmark judgments in the world. So this case was decided in 1973, and this case presented several views and ideas about the termination of pregnancy, about the legality and the constitutionality of the termination of pregnancy. So it was of the view of Justice Blackmun that the restrictive abortion legislations are unconstitutional and contravene the right to privacy of women, and also this view signified the obligation of the state to strike a balance between the recognition of women's rights and potential life of the fetuses. The basic issue which comes to the mind when reading the judgment is what the viable fetus is. This viable fetus is a term which is very scientific and which has a medical base, but this was discussed in this Roe versus Wade judgment as a significant aspect, and if we are giving a legal definition to this particular term, you know that the viable fetus is a stage of development of a particular type of a fetus in the stage of gestation, and this viable fetus is capable of living outside the womb of the mother, and this process is scientifically known as the ex utero existence. So the prominent consideration was paid to the fact whether the states must prioritize the interests of the viable fetuses. But in 2021, Roe versus Wade was overturned, and after overturning, it was apparent that the decision dismantled the 50 years of legal protection and paved the way for individual states to curtail or outright the banning of termination of pregnancy or abortions. And the banning or the prohibition of termination of pregnancy after 6 weeks, implying the fact that the fetal heartbeat is detected, is not supported by the medical specialists and especially the proponents of women's rights. And the opinion that they are going to uphold is that giving a specific time period stating the commencement of the fetal heartbeat is medically baseless and creates uncertainty. And also, most of the proponents to the women's rights and opponents to the fetal heartbeat consider this concept as a misleading concept. The concept of medical duty of care to the fetus is a bit odd and strange to the general public, because now we have heard that physicians owe a duty of care to the patients that they are meeting every day, but when it comes to a fetus, how can we measure and gauge the duty of care that the physicians owe? So the medical duty of care to the fetus is mainly interrelated to the viable fetus, and also this simply stands to an instance where the physicians owe beneficence obligations to the fetus capable in ex utero existence. That means the fetuses who are capable in living outside the womb of the mother. And when the medical duty of care to the fetus is concerned, that it grants legal personhood and elevates its position, and also that conflicts with the bodily autonomy and physical integrity of the woman. And on the other hand, the pregnancy is not merely a biological function, but it is sociological as well. And the activities of a woman are typically a matter of social construction, and the rights include the right to equality, right to dignity, physical integrity, autonomy, and right to information. And also, the woman's right to privacy includes the enjoyment of higher standard of health, and that includes the reproductive health as well. So the woman is capable of making autonomous decisions, and also she has the power of making certain decisions about the fact whether to have or not to have a child, and this is categorized as a derivative right under the due process signified by the 14th Amendment to the Constitution of the United States of America. So, if an authority compels a woman to continue a forced pregnancy that amounts to involuntary servitude, you know that the involuntary servitude is a concept which is rejected by most of the international jurisdictions as well as the most of the developed domestic jurisdictions. So, the 13th Amendment to the Constitution of United States of America rejected the slavery or the servitude, and also as far as the international context is concerned, the Article 8 of the International Covenant on Civil and Political Rights internationally rejected the concept of involuntary servitude. So it can be concluded that the prohibitions or the controllers on termination of pregnancy on the ground of fetal heartbeat paves the way for the woman to enter into forced procreation, and this impliedly and automatically converts to the involuntary servitude, which forces a woman to carry out a pregnancy that she does not want to continue. So when we are going to the conclusion of the presentation, we can see that we have concluded it by saying that the Texas Heartbeat Act 2021 has the effect of impeding the termination of pregnancies after the detection of the fetal heartbeat, and also there are proponents and also there are opponents who are against the concept of fetal heartbeat on the grounds of medical uncertainties. And also it has been accepted that the restrictions on termination of pregnancies amount to the violation of reproductive rights of women, and the Texas Heartbeat Act is a controversial legislation on medical and legal grounds, and prioritizing the interests of the fetus over the maternal well-being is considered as a violation of the freedoms of the pregnant women, which amount to involuntary servitude. So the over-glorification of the fetus and the over-glorification of the rights of the fetus would amount to the trampling on of the maternal rights, because we know that the fetus is identified as an entity who is depending on the body of the mother, and the sole decision making is on the mother to make decisions about the existence of the fetus. So it is concluded that the Fetal Heartbeat Act, the imposition of restrictions on the termination of pregnancy, amounts to the violation of the international law, especially the concept of involuntary servitude. Thank you. Behavior and develop.
Thank you very much, Ayodhya. That was really interesting, and I think you have gone into this ever controversial issue of women's rights versus children's rights, the right of the child versus the rights of the mother. I have a question, but let me open it up first. I'm sure there'll be a lot of questions here. Yes, Sanat.
Okay.
Go ahead. Yeah.
Yes. Thank you, Professor. Thank you, Ayodhya, for your interesting presentation. And this is a kind of a timely topic and controversial issue, as mentioned by Professor Kamina. So my question is that, have you looked at the reasons as to why Texas Heartbeat Act was introduced in the first place in 2021? Are there any specific reasons or were there any compelling reasons to introduce this particular legislation in Texas? You are on mute, Ayodhya.
Yes, sir. Thank you for the compliment. Yes, sir. The reasons are that because the fetus is now in the stage of glorification, and the most predominant reason for the introduction of the specific act is the emergence of certain reproductive technologies. One of such technology is the artificial placenta, where the emerging particular reproductive technology is introduced. An artificial womb is created, and the fetus is given the opportunity to grow as an external entity. So that is the first step. And when it comes to the USA, United States of America, they have implemented the Texas Heartbeat Act by stating that the emerging reproductive technologies in the world are causing in the glorification of the fetus, and that gives that paves the way for the emergence of certain fetal rights, and that is the basis of the enactment of the act.
Okay, thank you, Ayodhya. And also I have a small suggestion for you to develop your paper. Perhaps you could look at some jurisprudential thoughts as well as some theories regarding it. Since this is a very critical issue, you may need to make some kind of a modest argument in your research. So please look at Richard Posner's ideologies, because Richard Posner's ideologies regarding to body as a property. So his ideology, they provide some insights for you to develop your paper. Thank you very much.
Thank you, sir. Thank you.
Thank you, Sana. I have a quick question, Ayodhya. Now, as you know, abortion isn't unrestricted. Every country, they go to different extremes. Sri Lanka has no abortion at all legally. In the UK, you can abort, I think, up to 5 months. Which is a very long time, and every country has a certain period. What will be your recommendation to strike the balance between the rights of the mother and the rights of the child?
Rights of the mother. When we are talking about this act, madam, we can see that this medical opinion based, the medical opinion given in the Texas Heartbeat Act, that you are not allowed to abort your fetus when the 6 weeks of gestation is completed. But normally, when it comes to British Medical Association and mostly United States of America, it states that majorly a fetus becomes viable after the 20 weeks of gestation. Then the reason is, now the problem here is that we are giving an opportunity for an inviable fetus to survive and to trample on the rights of the mother by basing the argument on a medical uncertainty. So in my way, my individual perspective is that if we are granting rights to the inviable fetus, that can be justified by, viable fetus that can be justified, but when it comes to an inviable fetus, without a medical argument and a medical base or a medical certainty, that is something cannot be justified at all. So my answer is that if we are to balance the interest between these two, if we are restricting the reproductive autonomy of a mother on a medical certainty to protect the very life of a viable fetus, that can be justified. But when it comes to an inviable fetus, there are certain doubts.
Okay, right. Thank you. Any other questions? No. Okay, thank you, Ayodhya. That was very interesting, and I hope you will pursue the research. Shall we have the next one, Sanat, please? So the next one is, positive protection as the only savior to protect traditional knowledge, a comparative analysis.
Hi everyone, I'm Kavindu Hewadiganage and my presentation is based on the title Positive Protection as the Only Measure to Protect Traditional Knowledge, a Comparative Analysis. The objective of this research is to identify and assess the most appropriate and effective safeguarding strategy for traditional knowledge. The concept of intellectual property is prominently highlighted in the policy paradigm of the knowledge-based economy in the 21st century. As lucidly illustrated by Justice Richard Posner, intellectual property is a vital asset for businesses of all sizes in today's global economy. When considering that point of view from a socio-economic perspective, traditional knowledge can be identified as an untapped gold mine in Sri Lanka, and it could be properly commercialized while sharing benefits to the particular community and safeguarding traditional knowledge. To comprehend whether traditional knowledge could be effectively safeguarded by positive protection mechanisms, it is essential to define traditional knowledge. According to the definition of the World Intellectual Property Organization, traditional knowledge can be characterized as knowledge, know-how, abilities, and practices that are produced, continued, and passed on from generation to generation within a community. Traditional knowledge is not an individual right, and it is a shared right by a particular community. Traditional knowledge could be recognized as distinct identities of particular community. This is bestowed on people by their ancestors and endowed mostly by nature. As a result, traditional knowledge has an envious value, worth, and distinctive recognition associated with the spiritual element of the community. Sri Lanka has a vast store of undervalued, neglected, and misidentified traditional knowledge, which have generally gone antiquated or endangered owing to a variety of factors. This research proposes to introduce a positive protection mechanism to protect traditional knowledge while sustainably sharing the benefits of its true value. Centuries of misappropriation, theft, uninformed utilization, and exploitation have resulted in the destruction of traditional knowledge. Therefore, traditional knowledge requires more safeguarding as commercial theft spreads all over the world. Even though Sri Lanka and the majority of the third world countries are rich in having a treasure trove of traditional knowledge, it is yet to reach its true potential by reaping the benefits of the creative and innovative endeavors of their ancestral heritage. Glaring incidents of misappropriation of traditional knowledge demand for an adequate protection system consisting of positive protection mechanisms, and it can be identified as an essential socio-economic need of third world countries. The main research questions of this research are: what is the most effective and successful method of protecting traditional knowledge? And the second one is how do positive protection methods help to safeguard traditional knowledge? And in this research, it is hypothesized that the introduction of positive protection methods will safeguard traditional knowledge while sustainably utilizing the value of traditional knowledge. This research mainly falls into the qualitative research paradigm of legal research, and it was mainly carried out as a desk research. In terms of methodology, the black letter approach was employed as the dominant methodology, where the law in letters is considered rather than the law in action. Since the research intended to thoroughly analyze the current legal framework concerning protecting traditional knowledge and its ampleness, legislative enactments and frameworks were identified as vital. Therefore, comparative legal research and analysis were also followed extensively. When moved into the findings, numerous intellectual property tools can be utilized to safeguard traditional knowledge to a certain extent. Nevertheless, there seems to be no appropriate global protection system or instrument for this particular subject. The exact dimensions of the entitlement are still to be decided. This may result in the preservation of historic collective works, including knowledge that is helpful but not inventive according to intellectual property paradigm's requirements. Defensive protection is a series of techniques designed to prevent third parties from obtaining unauthorized intellectual property rights to traditional knowledge. There are several ways to implement this strategy, including disclosure of origin and traditional knowledge databases that would easily be utilized to maximize the productivity of prior art investigations. Positive protection strives to safeguard traditional knowledge by establishing positive rights that enable proprietors of traditional knowledge to safeguard and develop their knowledge. Establishing a liability system in which initial manufacturers or suppliers are rewarded through a benefit sharing arrangement and enacting a sui generis law are two options for putting this strategy into action. The Bonn Guidelines were the first worldwide regulation to guarantee that countries deliberately and efficiently deploy access and benefit sharing arrangements. Those regulations stressed the importance of countries developing a unified framework for access and benefit sharing that is appropriate for their jurisdictions. The Nagoya Protocol is a much more focused view of the situation, which emerged to be entered into force in 2014. It required stakeholders to cooperate in actions in accordance with their access obligations, benefit sharing obligations, and compliance obligations. This study mainly highlights positive protection methods that third world countries might build to safeguard their traditional knowledge through using the prescriptive approach, thereby facilitating the development of sui generis laws. Moreover, it could be accomplished through revisions such as the addition of new compounds, improvements of existing laws, or perhaps even the elimination of particular provisions from existing regulations. Article 27(3)(b) of the Agreement on Trade-related Aspects of Intellectual Property Rights provides World Trade Organization's members the option of establishing a sui generis system. This allows countries to design their own protection structures, which can aid in the safeguarding of their traditional knowledge. Peruvian sui generis law is regarded as one of the world's most productive and efficient sui generis strategies for the safeguarding of traditional knowledge. The Peruvian sui generis law clearly states that its goal is to promote the fair and equitable distribution of the advantages accruing from the use of collective traditional knowledge by Article 2 of the Peruvian law. Article 39 of the law specifically states that funds from benefit sharing will be directed to a fund for the development of indigenous people. Another third world country with an important sui generis law to protect traditional knowledge is Panama, namely by Panamanian Law number 20 of 2000. Panama has passed this legislation establishing a special regime for intellectual property relating to indigenous peoples' collective knowledge, in addition to the protection and security of their cultural identity and traditional knowledge. Remarkably, the law establishes civil and criminal penalties for violations of the traditional knowledge in Panama. The entirety of these rights will be granted to indigenous people only through the collective rights registration process, and this is mentioned in Article 16 of the sui generis law. As per Article 15 of the same law, when it comes to criminal offences concerning misappropriation of traditional knowledge and duplicating products while misusing the knowledge of Panamanian indigenous communities, half of the fine is apportioned to the advantage of the national treasure, while the other half is apportioned to the advantage of the respective community. When it comes to the Sri Lankan context, it is regrettable to understand that Sri Lanka's Intellectual Property Act is the only legal instrument that protects traditional knowledge, and that is also limited to folkloric manifestations. Folklore expressions are protected under Section 24 of the Intellectual Property Act, from duplicating and performing for the public. Despite this limited definition of the folkloric expression, safeguarding traditional knowledge in Sri Lanka presents a variety of challenges, including the difficulty that arises in terms of ownership, as well as the period of protection for folkloric expressions. When it considering the folklore expressions are original, the author should be identified. The origin of some expressions of folklore may be traced back centuries ago and would be deemed to be already in the public domain. Further, the limited duration of copyright protection disregards the intergenerational nature of traditional cultural expressions. The study's conclusion encourages Sri Lanka and other developing nations to adopt a framework not only for the regulation of traditional knowledge, but also for the correctly utilizing value of traditional knowledge by introducing positive protection mechanisms that match the needs of the particular society. This would provide legal clarity for both communities that possess traditional knowledge and other entities looking to use that wisdom related productions and services. In light of the benefits that traditional knowledge offers, the above mentioned type of structure congruent with a positive protection mechanism might be assisting to make the traditional knowledge accessible for beneficial use to the whole society by reaping the fruits of that wisdom while also ensuring that particular community members are fairly compensated. Thank you. Property is prominently high.
Thank you very much for that very, very interesting perspective on traditional knowledge, which is a very sort of hot topic. Now it's open for questions. Does anyone have a question? Yes, Dr. Sanam.
Okay, thank you very much for your presentation and timely topic, selecting a timely topic, Mr. Kavindu. So I have one question and one comment on your research or the presentation. The question is that why positive protection? So negative protection is available through some international standards as well as domestic laws, as you very correctly mentioned. Why you have specifically focused on positive protection? That is my question.
Yes, sir. Thank you so much. And that is my focus point of the research.
Please turn on your video so that the participants can see you.
Professor, there's a problem. He mentioned that there's a problem with the camera. That may be the reason, perhaps.
I'll try to connect, madam. I don't know whether it will be opened or not. Actually, my focus point is that correctly pointed out by Dr. Sanat, that there is the defensive protection as well as the positive protection. But in terms of my argument, there is no need to battle in a courthouse or go into a confusion. Rather than if we are going to protect traditional knowledge by benefit sharing system, it will be beneficial to the society as well as the community, because as in economically, the community will be getting the benefits, and as in the perspective of society, the traditional knowledge, wisdom will not be hide anywhere. Because defensive protection system encourages to avoid getting intellectual property rights for the particular traditional knowledge. So in my argument, I encourages all the governments of the third world countries to use positive protection because there will be no confusions, legal battles. It will be open to the society while giving benefits to the community as well.
Thank you very much.
Kavindu, I would like to follow up on that. By doing that, aren't you taking away the autonomy of the communities so that they are compelled to open up their traditional knowledge to others, even if they don't want to?
Yes, madam. In that point, if the particular community wants to hide their traditional knowledge and utilize their traditional knowledge their own, they are allowed to. But those who are willing to share their knowledge under a benefit sharing scheme, they should be encouraged to do so, because it will be a economic beneficial thing to a country.
Okay. So basically, you'll have to have a combination of positive and negative.
Yes, madam.
Okay.
Yes, right.
Okay. Thank you very much. That was a very interesting perspective on this. Are there any other questions? No. Okay, then we can get on to the next one. So the next one is
Honorable Chair.
Yes, please start, sir.
Honorable Chair, the panelists, the presenters. The topic is Sri Lanka's post-war implications on online falsehoods and manipulations, intangible national security menaces. So the research problem is the need to criminalize online falsehoods and manipulations that are threats to Sri Lanka's national security in the post-war context. The research objectives are to identify online falsehoods and manipulations, to identify the threats incurred to them by to Sri Lanka's national security, and to provide the research recommendations to denigrate and prevent the threats posed by online falsehoods and manipulations. The research questions are: what are online falsehoods and manipulations? What are the threats incurred them to by Sri Lanka's national security? And what are the recommendations to denigrate and prevent the threats posed by online falsehoods and manipulations? So, moving on to the introduction, the national security definition is not the definition that we knew, because now, at present, the definition has encompassed various elements. Earlier, it was only restricted to militaristic aspects. According to United Nations Chronicle, national security is the ability of a state to cater to the protection and defense of its citizenry, which means primary concerns on sovereignty and territorial integrity. Now, however, another scholar, moreover, they tell that traditional security is to safeguard the state from military aggression. Now, at present, national security is wide in scope. It encompasses various factors in addition to traditional security such as political, economic, environmental, energy, and cyber security. These threats are also facilitating the militaristic aspect. Same as the definition of national security, definition of war has also changed. The war has changed from militarist aspect for the virtual sphere. Now, social media is used as the biggest ideal platform to fight a war, where disinformation, misinformation, false information, hate speech likewise take place. And online falsehoods and manipulations are used by profit-driven individuals, politically driven individuals, terrorists, and underworld goons, such as people, to benefit themselves. So, according to the definition by two scholars, online falsehoods are unfounded and unverified online messages which leave behind the digital footprints on the internet. What is worrying is that such dubious messages are often mistaken as facts, and in turn cause people to take actions that they would not have taken otherwise. So people use social media, the online platform, which is the biggest platform, because it's widely available, cost-effective, time-saving, and technically literate people are there. So the research problem is the need to criminalize online falsehoods and manipulations, which are threats to national security of Sri Lanka. So I have resorted to qualitative methodology, where The research is of qualitative nature, is multi-method research and study things by attempting to interpret the phenomena and study things in the natural settings. I have aided my research findings by using secondary sources such as journal articles, books, likewise, and also I have resorted to acts, which is like Online Falsehoods and Manipulations Act, which is number 18 of 2019 of Singapore and Canada's Tamil Genocide Education Week Act, and I have taken them into consideration. Okay, now looking at the results and discussion. Sri Lanka's post-war context. Before the war, Sri Lankan government fought a war against LTTE. Okay, this is often misperceived by LTT, and they are using it. LTT and International Network are telling that we have fought a war against Tamils. It is Sinhala versus Tamils. No, that's not the reality. The Sri Lankan government fought a war against the LTTE, the terrorist organization, which is the most ruthless organization. Okay, so LTT and International Network have shifted their warfare strategy, unlike where they use bombs and all. Now what they're doing is they're using the social media platform. They're alleging us of crimes that which we did not perform, such as they're telling that we have committed genocide, international humanitarian law violations, international law violations, and also causing intergenerational trauma, and snatching away the Tamil homeland, which are fictitious claims. So these unverified, untrue, false claims are often used in the social media, propagating, going on, always telling, circulating, they are commenting, they are liking, they are sharing, they are downloading. Now these lies are repetitive. Often what happens is that question arises whether they are true. It sets the precedence. So people will be thought of this, people will discuss about it, which is detrimental to the national security of Sri Lanka. Okay, now I'm telling you and I'm showcasing you an ideal example which shows the result of these misinformation campaigns conducted by LTT. Now, for an example, in Canada's Tamil Genocide Education Week Act, this was passed by the Ontario Parliament of Canada. According to the Act, Sri Lanka, they have mentioned that we have committed genocide, and they are using they're investing May 12th to 18th as a 7-day period ending on 18th of May, which is to proclaim it as a Tamil Genocide Education Week Act, and they are encouraging to educate themselves about and maintain the awareness of Tamil genocide and other types of genocide that occurred in the world history. So Sri Lanka have not committed genocide. They are learning Tamil genocide with other genocides. So with genocides that have occurred and a genocide that did not occur. So look at the gravity of it. So this information is circulated in social media, resulted in detrimental consequences to Sri Lanka's national security. In the same way, the Palermo City Council Memorandum of Association by the Italian Tamil community is another example where they followed the footprints of Canada's Tamil Genocide Education Week Act. They also learned the crimes happened, a crime which did not happen, but they are telling that we committed it. So they also conduct awareness raising activities, demonstration, collaborating with Tamil organizations in schools and public environment, informing and raising awareness among Palermo citizens and other Tamil genocide and other similar realities. Okay, now by now, we all understand this misinformation, falsehood, manipulations are a threat to national security. LTT and international networks are engaging in lobbying, litigation, and lawmaking. They are passing acts, resolutions, and MOUs. So they are also having front car sympathetic terror organizations. So these laws pave the way for unnecessary international interventions. As you can see, number of resolutions are passing against Sri Lanka. Tax concessions are taken now. They are threatening us. They are threatening the sovereignty of the country on the basis of committing a Tamil genocide. So by this, what happened is that it affects economic security, political stability of the country. So that's why I believe we need an act like Online Falsehood and Manipulations Act by Singapore. This act is to criminalize, denigrate, and combat fake news. In Singapore, this act is to prevent electronic communications of falsehoods and to safeguard against the use of online platform to communicate such falsehood, communication of such falsehood. So this law is to tackle the growing concerns over the scourge of fake news, misinformation communicated particularly through various online and social media platforms. That further stipulates measures to counteract the effects of communication to prevent misuse of online accounts and bots. The Act also has exemptions, correction directions, penalties, and remedies. However, Act respects freedom of expression. It does not call opinions, criticism, or parody. So all the Act is also extraterritorial in nature. Now, I believe Sri Lanka should also have an act like that. Not only Sri Lanka, all the countries need an act like this in order to clear out unnecessary doubt and fear in citizens. We need an act to counter falsehoods and manipulations, because there are false danger alert, people make the intelligence news, people fabricate government information, politically motivated government decisions are there, disclosure of unauthorized information, disinformation, misinformation, fake news, hate speech, online rumors, lots of things are taking place. So Sri Lanka need a legislation. Sri Lanka can refer to Singapore's Act. So, however, the Act needs calibrated remedies, a redress mechanism, a reporting mechanism, and a supervisory body, and collaborate with public and private entities. So I believe that Sri Lanka has been threatened by LTT and its international networks work, and we should counter online falsehoods and manipulations. Therefore, there are a plethora of recommendations that we can take into account. I believe we need the Act with the above mentioned, aforementioned characteristics I mentioned. And also we should raise public awareness, because public institutions should know the gravity of online falsehood, what it can do. And we have to instill information literacy, and we have to preserve freedom of expression while maintaining national security. But keep in mind, in case where national security and also freedom of expression comes, we have to strike a balance and give the precedence to national security. So, but this proposed act should not be a platform for revenge, punishment, or a haven for politically motivated and profit-driven individuals to silence the truth also. We have to identify the threat patterns, so we can identify this is what is happening in the society. That's a current trend, misinformation happening. So we can report it. So government must encourage us to instill technological capacity in them and report if they come across something like that. And also we need an intelligence platform for research development, which are key components to mitigate and prevent online falsehoods and manipulations. Private as well as governmental bodies must share resources and collaborate. Research and development can be conducted by referring jurisdictions. That's the end of my presentation. Thank you very much.
Thank you very much for that very interesting presentation. We are a little behind time, but we have time for a couple of questions. Any questions? Okay, let me ask one question. I found your presentation very interesting, but I'm also concerned about not only the infringement of freedom of speech, but the infringement of expressing political opinions, which are perfectly valid, and also the feasibility of applying this law extraterritorially. How would you overcome these issues?
Concerning to extraterritorial application, the reason I thought we need to resort to extraterritorial application is because even though we post something in Sri Lanka, people can view it everywhere. So by having consensus between other countries, I think if we have mutual cooperation and counter fake news mechanisms, we can overcome that. Also, all the social media companies, they have a reporting bodies in each country. So Sri Lanka also can seek their help and give the statute, like statute can use them as a intelligence platform to counter it.
Okay. Right, thank you. Any other questions? No. We can get on to the next presentation, Sanat.
Good day everyone. The topic of my research is a critical analysis of the legislative framework on the protection of geographical indications in Sri Lanka. Geographical indications (GI) simply entails the meaning a labeling system which recognizes a product or goods originating from a special and unique geographical area having and possessing the unique characteristics. In Sri Lanka, Ceylon tea, Ceylon cinnamon, black pepper, blue sapphire from the city of gems Ratnapura, Palmyra jaggery, Point Pedro spicy flat paddies, Malvana rambutan, Sienna pineapple, Jaffna mango, and buffalo curd of Ruhuna are some of the items that can be added to this list of origin-linked products. GI comes under the scope of intellectual property and is protected under the Intellectual Property Act. TRIPS agreement defines GI as indications which identify a product as originating in the territory of a member or a region or locality in that territory where a given quality, reputation or other characteristic of the good is essentially attributable to its geographical origin. Even though the TRIPS agreement specifically focuses on the protection of GI, it doesn't specifically mandate a specific mechanism to the member countries to protect the GIs. The agreement confers unfettered discretion to the member states to determine their own procedure in which the protection to be granted. Sri Lanka possesses both the preventive and positive method dealing with the protection of geographical indication. Recently, with the enactment of the Intellectual Property Amendment Act No. 8 of 2022, the registration process was introduced for the GIs, and this was a long-awaited amendment to the Intellectual Property Act. The registration of GIs was first brought up in 2018 Amendment Act No. 7 of 2018, where new subsection 4A was added immediately after subsection 4 of section 161 of the Intellectual Property Act No. 36 of 2003, and it empowered the minister to prescribe any geographical indication in respect of any goods or products for the purpose of this act. But the act was not promulgated by the needful regulations for setting up the needful registration mechanism and the efforts. In this backdrop, the paper aims to analyze the new provisions of the Amendment Act, which was enacted with the target of conferring and recognizing the GIs via registration process, and to determine to which extent the aforesaid amendment would be beneficial in giving due recognition to the GIs in the national and international sphere. The methodology of this research paper is mainly founded on qualitative methodology. A desk review is undertaken in relation to the provisions of the Paris Convention, Lisbon Agreement, Madrid Agreement, and TRIPS Agreement, Intellectual Property Act, and the Amendment Act, which also comprise as primary sources of the research. The literature extracted in the scholarly articles, law journals, etc. comprise as secondary sources of the research. The main and foremost objective of this paper is to have an in-depth analysis of the legislative provisions of the new Amendment Act and to analyze whether the new amendment has contributed substantially in protecting GI. The paper also strives to engage in a comparative analysis of foreign jurisdiction in relation to the legislative framework which deals with GI. The international regime pertaining to the protection of geographical indications are enshrined in the 4 multilateral treaties, the Paris Convention, Madrid Agreement, Lisbon Agreement, and TRIPS. Paris Convention for the Protection of Industrial Property identifies GI but doesn't provide any definition as to what constitutes GI. Madrid Agreement on Repression of False or Deceptive Indications of Source aims to improve and expand the provisions of the Paris Convention regarding the repression of false indications of source. Lisbon Agreement for the Protection of Appellations of Origin defines Appellation of Origin. Article 22 of TRIPS defines geographical indications. Amendment Act 2022, Section 6 inserts a new Section 160A to Section 160 of the Main Act, defines GI as an indication which identifies any goods as originating in the territory of a country or a region or locality in that territory, where a given quality, reputation, or other characteristic of the good is essentially attributable to its geographical origin. Goods include any manufactured or naturally available agricultural products, foods, wines, spirits, or any item of handicraft or industry. The same definition can be seen attributed to GI in the Intellectual Property Act No. 36 of 2003, and the definition comes under the interpretation section to the chapter named Marks and Trade Names. With the new Amendment Act, the definition was inserted to the chapter named Geographical Indications, thereby making it perhaps easier to read and making the GI section more coherent. The results and discussions of the research are as follows. 161A deals with the admissibility of geographical indications for registration. The section also can be introduced as an exception which is also akin to the negative protection of GI. It lists out circumstances in which a GI is refused for registration on grounds of law, morality, religion, accepted customs, or public order fallen into disuse in such country, or if the GI is identical with the term customary in common language, or if the name misleads or deceives the public. Section 161B deals as to who can apply for registration and how a person can apply for registration. Any association of persons or producers or any organization or authority established by any law representing the interest of the producers of any relevant goods can make the application for registration of the respective GI to the Director General. The section gives a room for a wide interpretation so as to include not only producers but also consumers, public officials, divisions, government sectors, state enterprises, local administrations, or any other government organizations, legal persons responsible for the geographical area in question. Section 161B, if Director General is of the opinion that the GI is admissible under Section 161A, he shall publish in Gazette the application submitted within 2 months from the date of receipt of the application as per Section 161C. Section 161D deals with the opposition to registration if any person in public is in opinion that the GI published under Section 161C is inadmissible under Section 161A within 3 months from date of publication, shall send a notice of opposition to the registration of the GI, specifying the grounds in which such GI is inadmissible for registration. The new Amendment Act provides for the possibility to oppose the proposed geographical indication registration. Section 161E stipulates the registration is valid for 10 years from date of application unless it is cancelled. The protection validity period can be introduced as a conducive period for effective protection of GI. In India, a 10-year renewable period is in place. Chapter 33A deals with the issue of certificate of registration and the register of GI, and Chapter 33B deals with the rights of a registered owner and administration of the register of GI. Lessons that can be learned from Serbia is that Serbia has very recently even gone a step further by registering its very first geographical indication for services offered in Zlatibor, a mountainous region in western Serbia known for its golden pines. The inclusion of services under the gamut of GI can be recognized as an incredible shift in the world. Inclusion of services into the gamut of GI would also be taken as a fresh approach to the legislature in making new amendments in protecting GI and bringing them to the next level. Finally, the paper concludes that the provisions of the Amendment Act has provided a conducive legal background for the proper protection of the GIs. The registration procedure, cancellation of the registration on some grounds, registration of GIs which were previously registered as certification marks, rights conferred to a registered owner of a GI could be treated as the most significant provisions in the Amendment Act via a concrete sui generis nature of protection. The indications which are having specific and unique attributes attached to the geographical area can be given due recognition in the national and international platform. Thank you.
Thank you very much for that very interesting topic. You have gone into a lot of new areas there. So we have time for a question. I'm sure Dr. Sanath has a question on this. Yes, Sanath, go.
Yes, Professor, thank you.
You're on mute.
Okay, am I audible?
Yes, yes.
So, Ms. Sujata, thank you very much for your presentation. Actually, this is a very timely, relevant topic because that the government has very recently introduced the amendment. So, actually, this is not a question, rather a comment. So perhaps you may need to look at some of the examples of the South Asian countries, particularly Pakistan. They introduced a new GI Act in 2021, and Bangladesh has a very sound legal regime for the protection of geographical indication, and even in India. So when you are developing your paper, I would like to suggest you to look at the examples of South Asian countries because these countries have some kind of similar economic, cultural, and social background, and geographical indication seems to be similar. Sri Lanka has Ceylon tea, India has Darjeeling tea, so something like that. So you would get more insightful, that the insights and suggestions by looking at South Asian subcontinent's example. So my suggestion is to look at these comparative examples in developing your paper. Thank you.
Thank you, sir. Thank you, ma'am.
Yeah. Do you have any response to that? No. Okay. Then we'll get on to the next presentation.
Good afternoon. The title of my presentation is Community Mediation and Justice, a Disconnect. So here's the outline of the presentation. I will start with a brief introduction, followed by the theoretical background, then the objectives of the study, the methodology used, discussion based on the findings, and conclude with some tentative thoughts. Community mediation is a method and a forum through which local minor disputes are resolved with the help of third-party mediators from the community. It is based on the ideology of alternative dispute resolution and popular justice that provide settlement in a non-adversarial, non-confrontational, and non-adjudicatory forum with the participation of the community in negotiating a settlement. It is practiced widely as an alternative to the formal courts or the formal legal system and can be seen in many countries, including in Sri Lanka. So my study was conducted to explore the perception of community mediation and its connection or disconnection with the idea of justice. In Sri Lanka, we have community mediation taking place throughout the island, and they are conducted through the mediation boards. And these mediation boards were established by the Mediation Boards Act No. 72 of 1988 and function under the purview of the Ministry of Justice. So there are currently over 300 mediation boards in total with more than 8,500 volunteer mediators who are appointed by the Mediation Boards Commission. So in each of these mediation boards, there are about 30 mediators appointed. And these mediation boards usually meet once a week on a Saturday. The process of mediation takes place in panels, and each panel has 3 mediators and disputants. Like in these pictures, they sit together and discuss the dispute and try to negotiate a settlement. The disputes can be brought to mediation boards by the disputants themselves, or the police, or the courts. Now, according to the Act, there are certain types of disputes that require mandatory mediation before they can be taken to courts. So, civil disputes relating to movable and immovable property, debt and damage up to the value of 500,000 rupees currently, criminal disputes such as assault, trespass, defamation, and also court referrals. These disputes have to be mediated first before they can be taken to courts. Divorce, testamentary cases, and fundamental rights petitions, as well as disputes involving persons of unsound mind, are not permitted to be mediated by mediation boards. At the end of mediation sessions, a settlement certificate or a non-settlement certificate, depending on the outcome, is issued by the mediation board. And the maximum number of sessions each dispute can have is 3. So on the third day or the third session, if the parties disputants cannot come to a settlement, then they are issued a non-settlement certificate, and thereafter, if they wish, they can proceed to courts. No legal obligation is there for one to be present at a session, even if they are called to be there. And settlements reached at the mediation boards are not enforceable by law. Statistics on mediation boards from the Ministry of Justice for 2021 indicate that there were 110,429 disputes that were completed by the mediation boards, of which 39% were discussed and settled, while 15% of those were discussed but could not be settled. But more importantly, 37% of these disputes could not be mediated due to the absence of one of the parties. Moving on to the theoretical background, the community mediation is not a new practice in Sri Lanka, and historically we have had similar forums of community level dispute resolution in the form of the Gam Sabha during the pre-colonial times, then the village tribunals and rural courts during the British period, and the conciliation boards that were set up in 1958, which can be seen as the predecessors to the current mediation boards. These conciliation boards existed for about 20 years before being repealed in 1978 due to various shortcomings. The current mediation boards, as I said before, were established in 1988. So they were established in part to provide an alternative to the formal courts, and its supporters or its proponents always highlight the efficiency, the easy access to dispute resolution, and cost effectiveness of mediation boards in various reports. Scholars from legal anthropology and socio-legal studies have studied community mediation with a focus on the culture of disputing and dynamics of disputing within the community. And according to Sally Merry, community mediation is defined as a negotiated settlement which involves, and I quote here, a process for making decisions and compelling compliance to a set of rules that is relatively informal in ritual and decorum, non-professional in language and personnel, local in scope and limited in jurisdiction. And as I said before, community mediation is based on the ideology of popular justice as in popular participation in justice, which is characterized as popular sovereignty, direct government by the people, the capacity of judges autonomously to exercise social power, a minimum level of institutionalization and bureaucratization, non-professionalized justice, and little specialization. So conceptually, popular justice can be seen as located at the boundary of local normative ordering on the one hand and the state law on the other hand, with ambiguous and shifting relations to each other. The critics of community mediation argue that the community mediation is a myth sustained through political propaganda and special interests, that it is a form of compromise, bargaining, and haggling, and that it also operates with power differentials of the communities. So against this backdrop, this study focused on exploring the ideas of community mediation and justice at the local level to understand the conceptual link between the ideas of community mediation and popular justice as envisaged by ADR. So the specific questions that included in the study: what is the perception of mediation boards among the disputants? What does mediation board represent? And does mediation relate to justice? A questionnaire survey was conducted at a mediation board in the Kalutara district, and the location was selected as it represented a mix of both urban and rural demographics, and self-administered questionnaires, including both close-ended and open-ended questions, were distributed. And the emerging themes were analyzed using a grounded theory approach that focuses on empirical data for exploratory theory generation. I will start with the general profile of the respondents or disputants, as it is important to understand and get a sense of who and what type of people come to mediation boards. So the gender of respondents and the age distribution, education level, and occupation of respondents. Here you can see that half the people had come to the mediation board for the first time, and that the reason they had come was for a financial dispute, and that also that they were asked to come to the mediation board by the other party. I have analyzed the responses and categorized them into 3 areas. First is on mediation as a mechanism for dispute resolution. So the responses suggest that the acceptance of mediation as a means to resolve disputes with high positive response to the usefulness of mediation boards. And the dominant phrases for the usefulness of mediation boards include ability to discuss, save money, resolve issues. However, the majority of the respondents were first time at mediation boards and for financial disputes, so which can be interpreted as seeing mediation as a cost-effective mechanism for financial disputes, and hence the optimism. Secondly, on understanding mediation as an alternative to formal courts, respondents said that they would also seek the support of Grama Niladhari, relatives, and priests in addition to lawyers when faced with a dispute, and that they consider mediation boards as an alternative to courts. And also there is a perception that mediators are better than lawyers. So this response suggests the acceptance of non-judicial dispute resolution process as a viable option. Mediation and justice response suggests that the focus on mediation seems to be more on the method of mediation, facilities, and the organization of mediation boards as opposed to ideas about justice. And there seems to be also an ambivalence towards mediation and justice when you look at the high positive perception of mediation at 87%, with the 64% saying that justice can be achieved through mediation. I want to conclude with some tentative thoughts. Tentative because it is still a work in progress. So community mediation is seen as a viable alternative to the formal legal system, but more from a utilitarian or practical perspective. And the idea of popular justice seems to be subsumed under these practical and operational concerns of mediation boards. What then is the relationship between community mediation and justice? Acceptance, yes, but justice? So is it a connection or a disconnection, or is it an ambivalent connection? What I feel is that more in-depth study of mediation boards as embedded in particular local socio-cultural context is needed to understand the relationship between community mediation and justice. And further research is critical not only as an academic interest, but also for policy direction in formulating appropriate reforms to dispute resolution. and thank you.
Thank you very much, Sepalika. That was really interesting. It's open for questions now. Yes, Anton.
Yeah, Professor Kamina, thank you. Dr. Sepalika, very interesting presentation. When I was, observing some of the mediation boards, two questions came into my mind. One is about, you rightly concluded, telling that you have to study further about local cultures, etc. Even, what I found was these are mediation board comprised of, monks and local teachers, etc., kind of elitist groups in the selected communities. And when some of the, kind of groups from marginalized communities go there, I understood these groups as they are representing two worlds. Sometimes this, when teachers say, okay, you can amicably sort this out, etc., they would nod their head and say that's fine, but that they may not be meeting the justice. So that is one of the confusion, one of the area I was thinking. The second comment I would like to get feedback from you is about is that how successful they are. It is connected to multiple personalities that we meet in the society. They may say, okay, I agree, and I'll settle the issue here. But once they go back to the village, in the bazaar, etc., they may again continue the same fight in a different format. So these are the two areas I was thinking. I don't have proper answer, but I would like to get your comment. Thank you.
Okay, thank you, Anton. I also don't have answers, but all I can say is like I said, mediation, community mediation needs to be looked at from a holistic, more contextual perspective. So for instance, I would like to know why the absentees, what they say about mediation. And so then whether it relates to justice, like you correctly asked, is a big question there. And also about community mediation, like you said, the mediators tend to be older people, a lot of teachers, retired public servants. They are the ones who are mostly, volunteer to be mediators. So then that power dynamics in the community also comes into play. So that also we have to be sort of sensitive and aware of. And then about follow-up, again, you have to do a community study to see what happens afterwards, because like I said, 3 times you can do mediation, and then if the dispute is not settled, then non-settlement certificate is issued, and if someone wants to go to courts, can do that. If not, then what happens? So I would also like to see what happens after these mediation sessions are concluded. So sorry, I don't really have answers to your questions, Anton.
Thank you, Sepalika.
Thank you. Any other question? Okay, then I think we have come to our final presentation, which is on right to life.
Professor Kamina, there's a last question from
sorry, Padmanesan, carry on. Sorry.
Sir, very simple, just clarification. Is that mediation board in Sri Lanka, is that same as it happens Panchayat Raj in India?
Similar, Padmanesan, okay. Panchayat,
Thank
yes.
You. Thank you.
Okay, thank you. We can put up the final presentation, sir.
Good afternoon, everyone. My presentation today will be on Right to Life as a Fundamental Right, a legal analysis on Sri Lankan Constitution. This is my content to be discussed. As of my introduction, right to life is one of the most inherent rights to mankind. This has been unanimously accepted by all schools of thought. By virtue of the right to life, any human being enjoys all the other rights prescribed and guaranteed by the Constitution and also by international documents. The right to life, which is an absolute right of every human being, is at the heart of all the other rights and freedoms as well. The enshrinement of a right in the Constitution itself is a proof that the fact that the said rights are guaranteed and protected by the supreme law of a country. In relation to Sri Lanka, Fundamental Rights Chapter of Sri Lanka's 1978 Constitution ensures the protection of fundamental human rights. However, the Sri Lankan Constitution makes no mention of the right to life. Sri Lanka retains its position implicitly and indirectly protecting the right to livelihood under Article 11 and Article 13(4) of the Constitution. In analyzing the importance of right to life, the researcher would achieve following objectives. They are to identify the importance of right to life internationally and domestically, to investigate the existing law in Sri Lanka relating to fundamental rights, to analyze countries where the right to life is enshrined in their own constitutions, and finally to synthesize the value of inclusion of right to life into Sri Lankan Constitution. When I move into the next slide, which is about the methods used, in order to carry out this research, the researcher has followed up qualitative method by gathering primary and secondary data. While analyzing and critically evaluating these sources, the research will fulfill research objectives. The Constitution of Sri Lanka 1978, the Constitution of India 1949, the Constitution of the Islamic Republic of Pakistan 1973 have been used as primary sources. And the secondary data will be collected from scholarly articles, journal articles, research papers, and relevant judicial decisions. When discussing international perspective on right to life as a fundamental right, Universal Declaration of Human Rights is the pioneering document which is adopted by the UN General Assembly. There, under Article 1 and Article 3, it stipulates the value of right to life. Other international documents which upholds the importance of right to life are International Covenant on Civil and Political Rights, Convention on the Prevention and Punishment of the Crime and Genocide, Convention against Torture and other cruel, inhuman or degrading treatment or punishment, and also at the European level, European Convention on Human Rights and Fundamental Freedoms. When moving into right to life in India, the fundamental right provided by Article 21 is one of the most important rights that the Constitution guarantees. Article 21 provides two rights. The first one is right to life and the second one is right to personal liberty. The Supreme Court of India considers this right as the heart of all fundamental rights. The interpretation of Article 21 is not narrow or restricted. Thus, the Indian Supreme Court has widely interpreted the right to life and its value to a human being. The court has provided a list of other rights also which are covered by Article 21. Right to privacy, right against public hanging, right to pollution-free water and air, right to doctor's assistance, right to shelter, right to education are only few of. The protection of life and personal liberty is available in the Indian Constitution to every person, citizens and foreigners alike. Anyway, this is not an absolute right. The state can impose restrictions on the right to life and liberty, yet it should be fair, reasonable and just as per the procedure established by law. The judicial intervention of India has ensured that the scope of Article 21 is not narrow or restricted as I mentioned below. It has been widened up by many judgments. For an example, in Maneka Gandhi versus Union of India, the Indian Supreme Court has significantly expanded the interpretation of Article 21 of the Indian Constitution. It was held by the Supreme Court that the right to life embodied in Article 21 of the Indian Constitution is not merely a physical right, but it also includes within its ambits the right to live with human dignity. Also, by expanding the horizons of Article 21, in Francis Corelli Mullin versus the Administrator, Union Territory of Delhi and others, it was held that the right to live includes the right to live with human dignity, with the bare necessities of life such as adequate nutrition, clothing, shelter and so forth. In Sunil Batra versus Delhi Administration, the Supreme Court further reiterated that the right to life includes the right to lead a healthy life so as to enjoy all the faculties of the human body in its prime conditions. Therefore, it is extremely evident that India has used Article 21 wide and amplitude, covering variety of rights which are aligned with life. When moving into right to life in Pakistan, the right to life was incorporated in the Constitution of the Islamic Republic of Pakistan in 1973, Article 9. Pakistan Supreme Court has enhanced the actual meaning of the right to life in many landmark cases decided. As an example, in Sheila Zia versus WAPDA, right to environmental protection has been included within the right to life. So, new dimensions of right to life has been introduced and widened up through the case law in Pakistan too. When it comes to Sri Lankan perspective in this regard, Sri Lanka is not a country where the right to life is considered to be included in the constitution. Yet, Article 11 read with Article 13(4) interprets the consequences of the right to life. The court has advanced this argument by stating the Constitution is a living document and should not be construed in a narrow and a pedantic manner. Thus, in Sri Lankan Supreme Court, it has recognized in many times the importance of right to life as well. For an example, in Ratnayaka Taranga Lakmali versus Niroshan Abekon, the Supreme Court of Sri Lanka held that the extrajudicial killing of a suspect in police custody violated the right to life. Also, in the very famous case Bulankulama versus Secretary, Ministry of Industrial Development, it was declared by the Supreme Court of Sri Lanka the right to livelihood was included in Article 14(1)(g) of the Sri Lanka's Constitution. Further, in Jayawardena versus Dharani Wijetilaka, Secretary, Ministry of Justice and Constitutional Affairs and others, it was held that the denial of natural justice prior to the cancellation of a petitioner's appointment was a violation of Constitution. Further, in Jayamuni Anuradha, Nilmini Wijesekara versus Sumedha Taranga and others, the right to life and the fundamental right had been violated due to cruel, inhuman treatment. So, as per my discussion, when comparing Indian and Pakistan's perspective on right to life as a fundamental right, it is identified that the inclusion of the right to life into their own constitutions made them reach far beyond. The word life has been interpreted in many horizons with the express inclusion of the right to life into their own constitutions. But meanwhile in Sri Lanka, people should wait until a positive interpretation is declared by the court when an infringement of a right related to life is identified. Therefore, for those reasons, Sri Lanka is at some uncertainty on guaranteeing the most important human right to a human being, which is to preserve social order and justice as well. Finally, as my conclusion and as of my recommendations, I would say The pinnacle of human rights remained the right to life. Right to life has been given a special concern than ever in many foreign jurisdictions. The countries have preserved the right to life by an express inclusion of the right as a fundamental right. More than ever in Sri Lankan history also, people are in a quest of guaranteeing their life as a fundamental right because of this economic and political instability. Unless the express inclusion of the right to life is preserved, it is hard to guarantee many other rights relating. Therefore, it has become the high time to amend the Constitution of Sri Lanka while placing express recognition of the right to life in Chapter 3 of the Constitution. Also, a speedy enshrinement of the right to life in the present Constitution as a constitutional amendment is strongly recommended. These are my references, and thank you very much for listening to me.
Thank you very much for that very interesting presentation. Now we have question and answer time, so we can take any questions. Any questions? We have a few minutes, so we can take some questions. Okay. Okay, so looks as if there are no questions. So that was the final presentation for this session on law. And I would like to thank all the 7 presenters who had put in a lot of hard work, come up with some very, very interesting research on a range of topics, covering mediation boards to the Constitution, to there were several on various aspects of intellectual property. And I think we all had a very interesting and fulfilling session on this. And once again, I would like to thank the presenters and the participants. I'm sure the participants' questions and comments would have also helped the presenters to take a fresh look at their research and perhaps get a new perspective on it. And so I think we're also a little behind time. So once again, thank you very much. And we can bring this session to a close. And I'm sure y'all are waiting to follow the next session. So thank you very much, everybody.
Thank you.
Thank you very much.
So the Open University of Sri Lanka, the legal department, was where I obtained my first degree. And that was a time when Professor Savithri Gunasekara was the head of the Department of Law. And I must say that we gained much from her experience. And I very well recall a particular viva in which I participated, the law of property. And the questioning, the manner in which he questioned us was a way forward for us to understand how the law has to operate, how the law has to function.
I would like to say that I am deeply and sincerely grateful for the university for imparting me with rich wealth of knowledge for I would not be what I am today if not for the education imparted by the university to me. I have started my career as a military officer, and after completion of 20 years, I became a lawyer and started my practice in 2017. From 2019 onwards, I became a lecturer of the Kotalawada Defence University.
The knowledge and the skills that I have gained from LLB degree program of Open University has been beneficial for me to enhance my knowledge and making public statements all the time.
The degree offered by the Department of Language Studies using the ODL philosophy. As a result, I gained my degree while working, offered me the flexibility to be a wealth creator outside the university and also combine and create knowledge within the university.
I have been in the teaching profession for the past 12 years. After the completion of the first year of this career, I thought of gaining a professional qualification which goes hand in hand with what I teach here in the school.
I decided to join OUSL in response to my passion to update myself as I crave to acquire new skills and discover new teaching methodologies in both language and literature teaching.
I am now a senior program officer working with the Muslim Women's Research and Action Forum. I graduated in 2008 at the Open University's BA program in Social Studies. This helped me to further my education, and I have also done my Masters in Development Studies and Public Policy.
You get to learn at your own pace. That is the best thing. Further, there are multiple entry and exit points with certificate level programs to graduate level programs up to postgraduate level programs. The department itself is a learning experience. It is where you can learn freely.
My field is development sector, working in INGOs for last 20 years, and following these two courses at OUSL helped me a lot in terms of deepening my knowledge and improving my analytical skills.
LLB degree program conducted by the Open University of Sri Lanka is one of the best law degree programs in the country.
I've written 2 novels and 2 collections of short stories. The novel, Playing Pillow Politics at MGK in 2012 won Sri Lanka's prestigious literary prize, the Gratian Award, all because of the knowledge and the experience I gained at the Open University of Sri Lanka.
Anybody interested in this course will definitely benefit in life, in society, personally, and give your best social human beings working together in Sri Lanka.
It is a golden opportunity, I believe, to broaden your horizons. And I consider BA in Social Sciences as a launching pad for dynamic and enterprising youth, and also those career professionals who want to advance in their relevant fields.
The Open University offers a very unique way for a student to study. Because it is distance learning, it gives you an opportunity of studying while getting along with your other aspects of life. For myself, I first entered law college, and I would say that the experience which I had enriched my legal career.
Invest and empower yourself at OUSL for for a brighter future.